penny. As I continue my series of shorts, I will focus today on one of the business aspects of being an arranger, copyright law. So this is about copyright laws and the arranger. So the purpose of this video is to quickly explain the laws as they relate to writing an arrangement of a copyright-protected work of music. First of all, what does copyright mean? When someone writes a book or composes a musical work or even takes a photograph, under copyright laws of the United States, the creator owns the rights to that creation and any derivative creation from that, including arrangements or transcriptions, etc. So what does this have to do with arranging? Well, if you're going to be an arranger, you must understand copyright law. If you want to arrange your work that is under copyright protection, you will need to obtain permission from the copyright holder. The copyright holder, by the way, is not always the composer. More on that as we go through this. Now, if you fail to do so as an arranger, you could be sued. If an arranger willfully fails to obtain permission, the fines can be well over $100,000 per incident. You don't want that. Just like other legal issues, ignorance of the law is no excuse. You get stopped for speeding and you say to the policeman, I didn't see the sign. It's not an excuse. You're not going to get away with it. Okay, what copyright law establishes? Okay, whenever a copyrighted song is arranged, transcribed, or adapted for another performing ensemble, the right to create the arrangement, transcription, or adaptation rests solely with the copyright owner. If you want to arrange copyright-protected work, you must obtain legal written permission in contract form. So somebody calls you and they want you to write a song for their marching band show, and it's under copyright protection. Before you even start, make sure you know what is going to be expected of you for this arrangement. Ask them if it's going to be part of a medley or it's going to stand alone. In other words, if another song is going to be part of the arrangement, you need to know that. The publishers or whoever holds the copyright might want to know that, so you need to know it. Now, if it's part of a marching band show, if my third movement in my marching band show is a copyright protected tune, it's not connected to the other two outside as part of the show, that's fine. They'll still stand alone. Another question to ask is this: will there be any major change to lyrics, melodies, or harmonies? Now, if you're writing an arrangement for some school band where there's going to be a vocalist and they want to change the words, be careful there. You should ask if your client expects changes, a lot of changes in harmony, and you need to pass that along to the copyright holder. Now, will there be changes in form or the addition of original material? That's going to be important. As I say, stick to the form. You can deviate at times or add some little things in there, but you got to be careful. The addition of original material could cause a problem, so please discuss that with your client before contacting the copyright holder. Please note this: after you finish your arrangement of a copyright-protected work, your arrangement belongs to the copyright holder. So if there's a lot of original material in there and the copyright holder says, hey, it's not a bad arrangement, I might want to market it. However, if there's too much original material, that original material may stop them from doing that. Let's talk about the main ways to get permission. I believe there's only two. Hire a lawyer or go through a legal site. And this is fine for simple arrangements. If you're simply taking a song and writing it just like the original, regardless of performance level, it may not bring any issues up with the copyright holder. So let the lawyer know these things. I wouldn't hire a lawyer in that case, but nonetheless, or do it yourself. If you plan on writing an arrangement with a lot of creativity and not just a simplified version of the work, you might want to do it yourself in order to make sure that you're covered. All right. As I explain this, I think it'll become a little more clear. Okay, here's my do-it-yourself permission guide. First thing you have to do is find the copyright holder. I have some links below to help you. Start with ASCAP, ACE, or other performing rights agencies to find the copyright holder. Now, a lot of times you're not going to get permission through these PROs, but you could find out who holds the copyright. You could also try the U.S. Copyright Office Public Catalog. They have a searchable database. Of course, that's for works written from 1978 and later. The only thing about some of these sites is you might put in a song name, and when you open up the database, you have 10 different versions of that under copyright. You have to find who holds the main copyright. You can try the Library of Congress. There's another place to go. A lot of times you could get lucky and just Google it and find out who owns copyright, but you have to do a little research. Now, again, the holder will probably not be the composer, or may be handled by a clearinghouse on behalf of the composer or a publisher. I'll talk about that in a minute. Publishers sometimes hold complete copyrights, or they share the copyright with the composer. You know, a composer will write something and wants it to be published. The publisher will take on the cost of publishing that piece of music in exchange for a percentage of the copyright and the royalties that come with it. And of course, now you're going to have to fill out the paperwork and send it in for approval. You may not know the fee schedule until that's complete, but you might. There will always be a fee for permission to copyright. Least I've paid is $25, and if we base the cost on dollars per minute, the most I was asked to pay was $300 for 6 seconds of music. A client wanted to include the little ditty from Clint Eastwood's movie The Good, the Bad, and the Ugly, and I would hum it here or play it, but they'd probably charge me for that. I wound up coming up with something that sounded very close to it, but different enough that we couldn't be charged a fee for copyright infringement. Okay, so let's say you know who the copyright holder is. You have to contact the copyright holder and find out what is needed to obtain permission to arrange. Have your client questions ready, just in case you're asked those questions. Give them the name of the song, along with the composers, possibly the date of the initial copyright, and the type of ensemble that will perform the arrangement. They should give you some paperwork. You need to fill it out completely and submit it with fees. When I talk about fees, that's something you need to talk about with your client. If your client says, I want you to write, a marching band show, these 3 movements, you could be creative there, but I do want to use this song in there. Well, tell them it's going to cost them, and that put it in your contract, because you might not know the fee up front. Put in your contract that they're going to be responsible for the fees. Now, once you find out the fee, you'll have to share that with them. They might change their mind. A little side note here. What if you're denied? Basically, if you get denied, you simply get denied. Just tell your client about it. Now, some copyright holders are very picky about who can arrange their music. Examples: the music of John Williams or any music originating with Disney is almost impossible to get copyright permission as a single custom arranger. Okay, that's just the way they are. Now, you may not be given a reason, but you can always ask. So if you're denied, you can say, "Can I ask why?" They might not tell you, but they might. Here's a note, though, and I see this all the time. If another school is using a custom arrangement, and you know they didn't obtain permission, especially let's say it's a John Williams piece, and it's a custom arrangement, they probably didn't obtain permission. I truly hope you don't turn them in. If they get found out, they will pay. But if you turn someone in, think about this. Anyone involved may not only pay a hefty fee, but also lose their job. It's up to you, but I would never do that to somebody. Okay, next step. Your responsibilities. When you get that document, permission form, read the fine print. Permission is usually granted for arranging one musical work for one client. You can't write it for one client and sell it the next year. That makes you a publisher, and that's a whole different agreement and much more expensive. Make sure the agreement covers the time that the arrangement will be needed. For example, you're writing a marching band show. This may be August through November for most schools, or if it's for a college, going into January, in case the team goes to a bowl. Sometimes these agreements only cover one concert. Just make sure that you give the copyright holder the exact amount of time that will be needed. So look at the limitations and let your client know of their responsibilities. Okay, finally, once you find out what the fee is, you got to pay it to move forward. Again, I include a clause in your contract. Also, when you get your receipt for paying the fees, print out a hard copy of the receipt and put it in storage. I'd also put it in cloud-based storage just to be safe. By the way, many times when you get copyright permission, when you finish your arrangement, you may have to upload it to their website, and they will allow the band director to download it from his computer. By the way, not just the score, but you have to include the parts with the score, usually in one document. Okay, once your arrangement is completed, again, always double check your work. This is not like do it just business. This is just smart. Well, nowadays, a lot of us use notation programs. I don't start my arrangements on notation programs. I always sketch them out. But once they're up in the notation program, what's nice about them is you could listen back, and you could listen to individual sections. Make sure that you don't have any wrong notes or harsh dissonances or errors in rhythm. Again, the copyright holder will own your arrangement. I don't want to talk about this now because it gets a little more complicated. You can copyright arrangements. But let's talk about that when we talk about public domain music in another video. Okay, some loose ends here. When is an arrangement not an arrangement? Well, a cover song is not an arrangement. If you have a band and you want to do a cover song of some work that's out there right now, and you do it exactly like the original, it's a cover song. However, certain interpretations are also not arrangements. A singer singing with a rhythm section, but putting her own slant on the interpretation is not an arrangement. That's an interpretation. However, if the singer records it and sells recordings, that's something she has to go through performing rights organizations to get permission for. Okay, I want to step back and talk about my intros and ensembles videos, where I used the tune Stompin' at the Savoy. That was I call it an arrangement, but in legal terms, when my band was playing it, we could have gotten away with just not worrying about it. All right, if you're arranging, something else you need to consider. If you're arranging for your own ensemble, let's say you have a band and you wrote your own arrangement for them, and you plan on performing at halftime shows, maybe making a recording, and maybe even selling it. Well, that's where you might have other problems. You might have to go through performing rights organization like ASCAP or BMI, and you might have to get a recording license, like from the Harry Fox Agency or something like that. You could look into that. I don't want to go into that right now. Okay, to wrap up, remember this: you always need permission to arrange your work under copyright protection. You probably have to research the copyright holder. Be prepared to answer questions regarding the arrangement and its uses. As you do this more and more, you might be asked questions over and over again that you could add to your client question list. Make sure you have discussed fees with your client and keep a hard copy of all receipts. In the future, I'm going to have a few shorts regarding the business end. For example, arranging music that's in the public domain. A lot of music that's in the public domain, mainly music written over 75 years ago and not recopyrighted, can be a great source of material for arrangements. I'm going to talk about performing rights organizations and about being your own publisher, the pros and cons of that. Okay, thank you again. I hope this helped you understand legalities of arranging and how to go about getting copyright permission. Now, if there's any questions or comments, you can leave them in the comments below, or you can email me. If anything about my presentation has been confusing, please feel free to criticize me or send me an email or put it in the comments, because I love arranging. It's one of the things I love most about music. And I want to be clear. So if I'm not, let me know. The criticism will help me to better my presentations in the future. Okay, thank you very much. See you again in the next one.